This is part 2 of the California Association of Realtors Residential Purchase and Sale Agreement. My name is John McConnin. I'm an attorney and a broker, and this is the seller payments to buyers section. This is the most important section. We're going to get to it in a minute, but let me just hit this out in order so that it makes sense. So here's seller credit to buyer. Now in the past, this might have been, I've been paid through there as an attorney many times. $4,000. I think I've seen $7 once if I did a lot of work. I could see it going to 10. I could see it at 2, really depending on what the lawyer's doing and how much work's going on. You could also use it to escrow costs, or in the past we might have offered $5,000 for carpet or $10,000 for painting carpets, things of that nature. Some sellers knew their homes needed work, but they're like, let's just offer them a credit instead of doing it now and getting it on the market. So that would be seller credit to buyer. I haven't seen a limit on this number in the past, but things have gotten a little sketchier now because of the class action suits and the concerns about buyer agent compensation. So if you're offering buyer agent compensation here or to agree to negotiate it, this number you could probably make any number you wanted. Now, what's the framework? So why is this here? Well, to me, mentally, in my framework would be, these are things you might have talked about ahead of time, you might have marketed, you might have advertised, not buyer agent compensation. That would be dealt with in this box. But like the credit to the buyer, the attorney's fees, just the things I just said. And this might be something that was negotiated afterwards, like, and you made the change. So this might be or this could be a buy down. Let's say 7% interest rates are a little too high for the buyer's agent, so you're going to buy down. You might put $20,000, $30,000 down to buy down the interest rates for the buyer on their loans. Maybe it will get them to qualify for the home. So you could put rate buy downs in here, maybe credits back to the buyer that would be negotiated after inspections. You might put that in there. So to me, if I was talking about it ahead of time and I knew it, that number would be there. If it's something I learn later, it would be here. But I don't think my framework is the be-all and end-all. The lawyer in me loves the fact it's vague enough. You could probably do whatever you wanted. Again, you just want to make sure you're not putting buyer agent compensation on the MLS. That will get the listing agent in a lot of trouble with fines in the MLS. Like when I was entering an agreement, entering things in for my listing, there are all these flags that were going up all the time. They're so sensitive to compensation being offered on the MLS, buyer agent compensation being offered, buyer agent compensation being offered on the MLS now. So watch out for that. And you know why? The class action suits, right? Now, this is where we deal with buyer agent compensation now. But I need to go over a little framework. In the past, there used to be a separate box in these agreements where the listing agent would confirm to the buyer's agent that yes, the listing agent's offering 2.5% in concert with the seller. And what happened was in the past, and this is why agents got sued, the listing agent would go in and say, it's a 6% listing, 3.5% goes to me, 2.5% to the buyer's agent, or whatever they agreed ahead of time. Later listing agreements actually said the amount, so it'd be 2.5% or 3%, or a flat number could be there too. And then the listing agent, when they went on the MLS, they'd say, we're offering 2.5% or 3%. Now, that's gone. That can't even be there anymore. This is a good thing and a bad thing. I have a lot of videos on it. I would say that if you are going to offer buyer agent compensation, you should market it ahead of time. Like if you already know, hey, when these offers are coming in, I know the buyer's agents are going to be requesting the money. I'm going to market to them ahead of time and say, we're not just at 2.5% or 3%, we're at 3.5%. Because we value buyer's agents. Come see the property, make offers. Like I'd really leverage. I'd either be at 0 for a period of time, or I would be at a really good number to leverage it, to just get buyer's agents happy to show my property. I would go to the MLS and say we're offering an extra % to buyers if we get a contract in the next 30 days, and that gets accepted. I would put it in emails. I would market it on social media, particularly with respect to open houses. Yes, we're cooperating with buyer's agents, 3% offered. I would talk to the sellers about this. Why? Because sellers, if you can get into multiple offer situations, you're going to see that as you get closer and closer to fair market value, the buyer agent compensations go down to zero anyway. You want to use buyer agent compensation to get offers coming into your property. I have videos on this that I've explained concurrently as was happening on my previous listing in the past. You might want to check those out. Now, to me, and I have a seller to listing agent form, the seller needs to take control of the buyer agent compensation issue ahead of time. I think there's a lot to be said for zero the entire time in some markets. But let me just say every listing should be documented and start at zero. I have other videos on that. I don't want to go into the legal reasons, the steering reasons, the antitrust reasons, but you need to document. Like your listing agent doesn't have one of these forms. You need to go to my website, winnerscheck.com, and get my seller to listing agent form and document that you're starting at zero. It will save your realtor problems. It will save you potentially serious problems. Also, you'll then realize whether you want to do it the realtor way, which is passive. This is what happens. You see this right here. This is the offer coming in from the buyer. It's going to say payment to buyers, seller payment for buyer agents, seller payment for buyer's obligation to compensate buyer's broker, buyer's compensation affirmation. So this really can be seen as two parts, right? This hooks up with the second paragraph. Seller agreed to pay out of the transaction proceeds. You know the buyer's agents are going to be asking for 2.5% or 3% because they have to negotiate, according to the realtor rules, they have to negotiate the compensation level before they even show the property. That's not the California rule. California rule is that the amount only has to be delineated or ascertained or written out as soon as practicable. It's not before the first showing. But the trade association rule is if your real estate agent is a realtor or a National Association of Realtor member, it's a trade association rule that says they have to get you to agree to a payment amount ahead of time. To me, that's terrible because that's not the law in California. And I have other videos on that. But right now, seller agrees to pay out of their transaction proceeds. And the realtors are, if they have to go for it, they're going for it big. It's my understanding, time after time, 2.5% or 3% of the final purchase price. They could do a flat fee here. That would be better legally. This could be used maybe as or blank toward obligation. So they're saying you would have $10,000 towards the obligation, but nevertheless, it's going to come in at 2.5% or 3% right there. Now let's look at the second part together. Buyer compensation affirmation. Buyer, this is going to be you, affirmatively represents that at this time the offer is made, buyers have written agreement. That's kind of law in California. It's valid. Well, I mean, if it's a good agreement, written well, it should be. Covers this property and provides compensation for no less than the amount stated above. Now, this is tricky. This is where the associations have been doing their best to keep agent compensation high. They're making the buyer's agents do it ahead of time, and they're making a buyer affirmatively represent that they didn't agree to 1%, but they're asking 3% just to help out their buyer anyway. I mean, I just feel that combining these things is sort of breaching the fiduciary duty of a buyer's agent to the buyer. But nevertheless, that's what these trade associations are doing. I have a feeling there's going to be a lot of lawsuits about this over time. There's so much video and so many things to discuss about this that I have videos out there, but frankly, there's two processes for this. And let me just say, as a seller, I don't know that you want to be tied into this garbage either. So you want to have all sorts. You need form. If you're going to agree to buyer agent compensation, you need disclaimers. You need acknowledgments from the buyers and the buyer's agents signed to protect you. If you're a buyer, you might want to consider my buyer representation agreement. I think it's a lot better than the California Association of Realtors one, and it is compliant with California law, in my estimation. So you can get these forms at winnerscheck.com. I would go to winnerscheck.com and get the listing. It's very important, actually. The seller to listing agent form to protect you. And the buyer's agents, I don't know that, like this is, can you see how tricky this is? They're like, you're going to lock in at 3% and you're affirming. Like, how is this in your interest as a buyer that you have to affirm that you have a written agreement that provides for compensation no less than the amount stated above? Like, why couldn't you ask for 5% buyer agent compensation if you wanted? Even though you only agreed to pay your buyer 1%. Like this would be a good negotiation tactic. Why are the realtor associations taking that away from you? Like, you could ask for 3% and pay your agent $5,000. Why? This is your contract between you and the seller. So, I just crossed that. I would consider crossing that out. Now, your realtor can't do it, but you can, or an attorney can. I find this repulsive, actually. So, now, in the next video, I'm going to cover the rest of this agreement. And then we're going to talk about the outs that okay, so these agreements, as I said previously, are set up to make it easy for buyers to make offers, and there's outs. You should be aware of those outs and why you might want to change some of those outs in an up market or change some of them outs in a down market, particularly in a down market. You do not want to give buyers 17 days like you see all throughout here. You don't want to give all these outs to buyers to shop your deal or wait. Because remember, in a weakening market or down market, brokerages start counseling their listing agents to tell their clients that they want to be the best priced home on the market so that they sell their home. And it definitely worked in California. I mean, we had plenty of sales going on throughout the process. It was just like, if this property's higher and less valuable, it just helped this property sell. So people were like, I want to be the best priced home. And you go in there, you'd sell, people would see the new number, and then these guys would come down, and then someone else would come in and beat them. And that's why there was a race to the bottom. You don't want to give. And buyers became aware of this after a while, so they would be under contract, wait to see if something else came on the market. If it did, they get out of this one. Like, you don't want to be so we'll go over that in part 3, and then in part 4, we'll go over the rest of this agreement. So that'd be the California Residential Purchase and Sale Agreement, parts 3 and 4. Thanks. My name's John McConnin. You can get the forms I talked about at winnerscheck.com. Winners Check, or before buying or selling real estate, Winners Check.